She sued a tech giant for exposing her. They sued her back for triple. She sued a Fortune 500 company for leaking her most private information. They turned around and sued her for 3 times as much. For 11 years, the woman at the center of this case had lived quietly in a suburb outside of Portland, Oregon. She worked as a part-time dental hygienist, raised 2 teenagers, and by every account, kept to herself. Her neighbor across the street had introduced her to a home security app called SafeNest, a subscription-based platform owned by a mid-sized tech corporation that had quietly become one of the largest residential surveillance networks in the country. She signed up in March, uploaded her household documents for their Secure Vault identity protection feature, and paid her $14.99 monthly fee without thinking twice. Then, in September of the following year, SafeNest suffered a data breach. The company confirmed it publicly, 11 days after it happened. Among the files exposed, her social security number, a scanned copy of her children's birth certificates, her banking routing information, and a private legal document she had uploaded detailing a prior domestic violence restraining order. That last document, once leaked, made its way to her abuser's attorney in a separate custody proceeding. Within 6 weeks, her attorney called it a disaster for her case. She lost primary custody of her youngest child in November. She sued SafeNest for $2.4 million, citing negligent data storage, breach of fiduciary duty, emotional distress, and consequential damages tied directly to the custody outcome. Her attorney argued the breach wasn't an accident. It was negligence dressed up as misfortune. Discovery revealed that SafeNest had received an internal security audit 9 months before the breach, flagging their Secure Vault encryption as critically outdated. The company had budgeted a fix. Then, after a merger delay, the project was deprioritized. The plaintiff's team presented that internal memo to the jury. The project manager who wrote it had recommended immediate remediation. The recommendation was marked resolved in the system 6 weeks later, without any actual update being deployed. She testified for 2 hours. She described watching her youngest pack a suitcase. She did not cry in the stand. She didn't need to. SafeNest's legal team was not interested in settling quietly. 2 weeks after the lawsuit was filed, the corporation countersued for $7.2 million, triple the original claim. Their argument was threefold. First, they alleged the plaintiff had violated her user agreement by uploading a legal document that contained third-party identifying information, specifically her abuser's full name and case number, which they argued constituted a terms of service breach. Second, they claimed her public statements to a local news outlet, in which she called the company criminally negligent, constituted defamation and had caused measurable harm to their stock price and brand reputation. Third, they alleged her attorney had improperly obtained internal communications during discovery in a manner that exceeded the scope of the court's order. The defamation claim, legal analysts noted at the time, was aggressive. It was also, some argued, a message to other plaintiffs considering similar suits. The twist arrived on day 6 of proceedings, delivered not by either attorney, but by SafeNest's own witness. The company called their chief privacy officer to testify in their defense. Under cross-examination, he confirmed that the terms of service update, the one that technically prohibited uploading legal documents, had been issued 4 days after the plaintiff created her account. She had never been notified of the change. She had never reconsented. The original agreement she signed contained no such restriction. The plaintiff's attorney let the silence hang in the courtroom for a long moment before asking just one follow-up question. So the rule she allegedly broke, she never agreed to it? The witness said yes. The judge ruled in favor of the plaintiff on all primary counts. SafeNest was ordered to pay $185 million as damages, reduced from the original claim due to partial comparative fault. As the court found the plaintiff bore some responsibility for uploading sensitive documents to a third-party app, the defamation countersuit was dismissed in full. The discovery misconduct allegation was referred to the state bar, which later found no violation. The terms of service breach counterclaim was thrown out entirely. SafeNest issued a statement calling the verdict respectful of the legal process and announcing a voluntary security overhaul. 3 months later, they quietly discontinued the Secure Vault feature. The plaintiff did not regain custody in the immediate aftermath. Her attorney filed a motion in family court citing the illegitimacy of the leaked document as evidence. That proceeding was still ongoing at the time of this report. The $185 million didn't undo what was done. It didn't bring her child home. It paid her legal fees, put money in an account, and validated what she always knew. that the company had failed her. But here's the question that lingers. When a corporation uses a counter lawsuit not to seek justice, but to silence someone, does winning still feel like justice? Or does it just mean you could afford to fight back?